need more than just a will? The short answer is yes. A will plans for who gets what, but that is not the only question that should be answered in your estate planning. An estate plan ensures that all of the important legal planning questions are covered. Who's caring for your children if you become temporarily incapacitated? Who's in charge of your medical and financial decisions during that time? And ultimately, who would end up raising your children if something were to happen to you? If you want to be assured that all of these questions will have an answer when you pass, then you will absolutely need more than just a will. Every adult should have a power of attorney. This document determines who will be responsible for making decisions regarding assets, healthcare, and estate planning if you are unable to handle your own affairs. If there is a time of life where you become unable to handle things on your own, which statistically happens at some point to over 80% of us, and you do not have a power of attorney, then the court may appoint one and you may not have a say in who is chosen to act as the one in control during your time of need. You will need a living will, which outlines a plan for your care during a time of incapacity, and it sets forth any end-of-the-life decisions ahead of time if you ever become unable to make those decisions in the moment. In addition, a HIPAA release document authorizes your healthcare providers to share protected patient health information to your loved ones. If no such authorization exists, you risk vital healthcare information being withheld from people who may need it to assist you, such as a caregiver or even a close relative. For parents of minors, you want to arrange that guardianship is completely covered, both short-term guardianship for emergency situations and long-term guardianship for raising your children in the event that something happens to you. Having guardianship documents readily available during an emergency prevents your children from having to endure any stress of having the court appoint a guardian or putting your children through foster care. Leaving letters in your estate plan to your children and appointed guardians with things you would want them to know about your values and future advice can help your guardians raise your children the way you would have liked, and leaves your children with a sense of comfort and connection that they can always revisit. A good estate plan covers all of these things, and a will does not. It ensures that everyone ultimately knows your wishes and values when you pass away. Beware the fast do-it-yourself online make-a-will programs. Those companies are happy to take your money and to give you a will, but the will won't cover the vast majority of what you need in your estate plan. People have all kinds of needs and issues that come up during their lifetimes that good legal planning documents can help make easier. Wills, by contrast, are only legally workable after you are gone and cannot be used while you're alive. That's why your guardianship nomination should always be a separate legal document from your will. And then, without a trust, wills often require the month-long public and costly probate court process before anything can be done. This is why you need more than just a will.